collaboration. As we move towards a more integrated and resilient global economy, ease of doing business becomes not just a policy goal, but a strategic imperative. It determines how quickly and confidently investors can turn ideas into actions and partnerships into progress. As the leading body promoting trade and investment between India and the US for over 5 decades, the Indo-American Chamber of Commerce has always strived as a trusted bridge between governments, industry, and thought leaders. Through platforms like this, we aim to facilitate dialogue and solutions, to represent the voice of business to policymakers and create new opportunities for collaboration, innovation, and investment. We are at a unique inflection point today where India is emerging as a global growth engine and the United States continues to lead in innovation and capital. Together, we can build a future that is economically robust, strategically aligned, and globally impactful. With that, I once again welcome you to this webinar and look forward to an enriching discussion that will spark new ideas and partnerships. I am delighted to introduce our moderator for the session today. Ms. Vanita Bhargava is a partner in the dispute resolution practice group of Khaitan and Company. Her fora of practice include the Supreme Court, High Court, National Green Tribunal, Mining Tribunal, National Company Law Tribunal, and quasi-judicial tribunals. Vanita has been recognized and awarded as the Dispute Resolution Lawyer of the Year 2024 by Legal in Era Indian Legal Awards and the Best Environment Lawyer 2023-24 by BW Legal Leaders Awards. She has also won the award for being the Star Woman of the Year 2023. She has also been recognized as the Environment Lawyer of the Year by Women in Business Law Awards Asia 2022. Vanita ji, there are so many numerous awards that you have won. I will not read out
You can skip
all,
that.
but we are extremely privileged that you are going to be moderating this session. So with this, I hand over the platform to you. Thank you.
Thank you so much, Dr. Chauhan, for the kind introduction. Good evening, everyone. It's a privilege to be here as your moderator for today's webinar on ease of doing business and bilateral investment made easy, hosted by the Indo-American Chamber of Commerce, North India Council, in association with our esteemed partners, Khaitan and Company, and RKCA and Company LLP Chartered Accountants. As Dr. Chauhan mentioned, in the contemporary global economy, attracting foreign investment is a key priority for developing and developed nations alike. Two critical mechanisms that support this objective are the ease of doing business framework and bilateral investment treaties. The ease of doing business concept refers to the regulatory and institutional environment that influences the ability of firms to start, operate. I'll just continue. The ease of doing business concept refers to the regulatory and institutional environment that influences the ability of firms to start, operate, and expand within a country. It encompasses various indicators such as starting a business, obtaining permits, enforcing contracts, paying taxes, and protecting investors. A high ease of doing business ranking signifies a streamlined regulatory framework which can lead to increased investor confidence and economic growth. On the other hand, bilateral investment treaties are international agreements between two countries that establish the terms and conditions under which private investment from one country is protected in the other. BITs typically include provisions for fair and equitable treatment, protection against expropriation without compensation, free transfer of capital, and access to international dispute resolution mechanisms. These treaties aim to mitigate the political and legal risks that investors might face, thereby encouraging cross-border investments. Together, the ease of doing business framework and BITs form a complementary structure. While the former While the former ensures an efficient and predictable business environment domestically, the latter provides international legal assurances that safeguard investments from undue interference. We are at a pivotal moment in the India US economic relationship. Prime Minister Narendra Modi and US President Donald Trump jointly launched the India US Compact initiative, which focused on military partnership, commerce, and technology cooperation in February. And this week, the Indian Foreign Secretary and US Under Secretary for Industry and Security are meeting for a strategic dialogue to discuss the roadmap to strengthen collaboration in semiconductors, artificial intelligence, clean energy, and defense innovation. India US business relationships are seeing new heights with the United States International Development Finance Corporation committing over $500 million in investments for infrastructure and clean energy projects in India. This signals not only investor confidence, but a growing recognition of India as a strategic long term partner. Similarly, Indian tech and pharmaceutical companies continue to expand their presence in the US, from startups establishing innovation hubs in Silicon Valley to conglomerates investing in advanced manufacturing across the United States. However, it is important to mention that all these initiatives are taking place under the clouds of a tariff war. Historically, this progress hasn't happened in isolation. It has been made possible by focused policy reforms, legal frameworks, and sustained dialogue on both sides to enhance ease of doing business. For instance, India's efforts on the Gift City initiative and reforms around single window clearances, faster dispute resolution, and tax rationalization have created a more welcoming environment for foreign investors. Meanwhile, the US has offered tariff relief and shown a willingness to engage a policy dialogue through US India Trade Policy Forum. However, several persistent challenges continue to hinder the full realization of a business friendly environment, like complex regulatory frameworks, slow judicial processes, land acquisition and property rights, taxation complexity, inconsistent policy implementation, infrastructure gaps, labor law rigidities, administrative delays, access to finance, etc. Moreover, in recent years, BITs have come under scrutiny for various legal, economic, and political challenges. Countries, including India, have begun re-evaluating their BIT regimes in response to growing concerns over sovereignty, fairness, and development priorities. And that's exactly why we are here today, to decode these developments, to discuss what more needs to be done, and to better understand the practical aspects of doing cross border business from the lens of law, policy, and industry. We have with us today a stellar panel of thought leaders and practitioners who bring perspectives from international law, corporate affairs, and strategic policy advisory. Let me take a moment to introduce them. Our first panelist is Mr. Iain Sandford, who's a senior partner at Foley Ho. Iain helps clients deploy strategies to resolve cross-border issues in relation to international economic disputes and compliance challenges. He has represented numerous states in WTO disputes as well as states and international organizations in advisory proceedings before other courts and tribunals. He also has experience as a panelist in WTO dispute settlement and in commercial mediation, both as counsel and mediator. He is listed on the WTO's indicative list of dispute settlement panelists, the EU's list of candidates suitable for appointment as chairpersons for arbitrations and under EU trade agreements, and the WIPO list of neutrals. Iain also has extensive experience with helping commercial actors navigate cross border economic challenges, including advising investors in disputes, assisting corporations with trade compliance, and dealing with international intellectual property protection. As a former public servant in New Zealand, he was counsel to teams negotiating a broad range of intergovernmental agreements and arrangements, including investment treaties. Our second panelist, Dr. Sangeeta Sharma, is a professor of neuropsychopharmacology at Institute of Human Behavior and Allied Sciences and president, Delhi Youth Society for Promotion of Rational Use of Drugs. Her core expertise areas include clinical pharmacology, promoting rational use of medicines, especially antimicrobial use and AMR, medication safety, quality in healthcare. She has a rich, diversified professional and managerial experience in healthcare and has served as technical coordinator India WHO Essential Drugs Program, medical superintendent and secretary, Medical Council of India. She has conducted more than 300 workshops to build capacity for doctors, nurses, and pharmacists. Her pioneering work is a book, Standard Treatment Guidelines, a manual for medical therapeutics. Several Indian states have adapted this book. She has also written a book on pharmacy management, standard operating procedures. She is serving on the ethics committee of several national and academic institutions. Dr. Anadi N Sinha, our third panelist, is a seasoned HR veteran and accomplished business strategist with over 40 years of rich cross-industry experience spanning the automotive, electronics, telecom, and retail sectors. He is widely recognized for his exceptional networking, people skills, and his ability to align external and internal stakeholders with broader business goals to drive organizational success. He's currently serving as the Director, Senior President, Group Corporate Affairs at Uno Minda Limited. His career journey includes leadership roles at prominent organizations such as Tata, Bharti Airtel, Bridgestone, Lupin, and Kelvinator, underscoring his versatile expertise and leadership acumen. Renowned as a reliable point of contact for employees and management alike, he's a trusted partner to executive leadership, helping them anticipate future challenges and align corporate affairs strategies with evolving business needs. His ability to catalyze effective change and nurture talent driven cultures has cemented his reputation as a transformative leader in the industry. Our fourth panelist, Mr. Rahul Kapoor, is the founder and managing partner of RKCA and Company LLP Chartered Accountants, one of India's leading chartered accountancy firms founded nearly 4 decades ago. A dynamic individual and a man of numbers, Rahul is an authority when it comes to domains such as international taxation, M&A advisory, cross-border transaction, global corporate structuring, and critical business issues. It was his meticulous understanding of accountancy, taxation, and business processes that led to the inception of RKCA and Company, which is currently a guiding light of businesses across scales as well as individuals. An All India topper in economics and an All India rank holder in CA final exam of 1984, Rahul Kapoor is an alumnus of Hindu College where he pursued his graduation in commerce stream. It's his vision and foresighted approach that makes RKCA and Company a pioneering name in India in the accountancy, taxation, and financial advisory space. With that, if I may call upon our first panelist, Mr. Iain Sandford, to make his presentation.
Well, thank you very much, Madam Chair. And if I could just check as a first point, can people hear me? Is my microphone working? Can people hear me?
We can hear you.
Fantastic. I've had a difficult time connecting today, so I'm really pleased that you can see me, that I can see you, and that you can hear me. So first, let me say thank you very much for that kind introduction, and let me say that it's a real pleasure to join this distinguished panel here today. I'm looking forward to the discussion. We meet at a particularly uncertain time for traders and business people at the moment. I cannot, I regret, make the world a more predictable place, but as together with my team who's helping me with today's presentation, I hope that I'll be able to give you two useful insights today. The first is to give you a snapshot of where things stand with US tariff policy. And secondly, I'd like to give you some strategies for proactively engaging with today's uncertainty and for reacting to new developments. I'm going to display a few slides just to sort of guide through my presentation. So let's see if that works now. Can you see my slides? I hope so. Okay, so first in terms of a snapshot of where things are at with US tariffs. And I must say these things are developing in real time. Just last night, the US Court of International Trade issued an important ruling, effectively striking down many of the tariffs that President Trump has imposed since he took office. We'll talk about that a bit later, and I think it'll be appealed. I think it's likely to be appealed. So it's not the final word, but it just underscores for me how quickly things are developing and frankly, how uncertain times are. Quite quickly, let me just run through this slide. Since taking office, President Trump has imposed new tariffs under several different legal bases. The first of these bases was the International Economic Emergency Powers Act, or the IEPA. And President Trump has used those to impose or threaten tariffs on a number of countries, particularly Canada, Mexico, and China, with respect to an emergency that the president has declared dealing with the importation of fentanyl into the United States. The President has also empowered the Secretary of State to impose tariffs on countries that import Venezuelan oil. He's also threatened to use that power with respect to Iranian and Russian oil. No tariffs are currently in effect with respect to that power, but the Secretary could issue those at any time. Thirdly, under the IEPA, the President famously imposed 10% tariffs on all countries and higher tariffs on selected countries. Those measures, until last night, were in force, although some of them have been paused, and we'll see what happens with that next. In addition to the IEPA tariffs, the President has also imposed tariffs under Section 232 of the Trade Expansion Act. He's done that in two ways. First, he has varied Section 232 measures on steel and aluminium and on automobiles and auto parts, so that a blanket of 25% tariffs are imposed on imports from all sources. That's a variation, removing some of the exemptions that were in place before. Both of those sets of measures were imposed based on investigations that had happened during the first Trump administration. So he was able to act very quickly to vary those existing measures. There have subsequently been some exemptions. Notably, the UK became the first country to negotiate some exemptions from those tariffs a few weeks ago. In addition to those tariffs that have been imposed, there are also investigations with respect to wood, copper, pharmaceuticals, semiconductors, trucks, aircraft, jet engines, and critical minerals. All under Section 232, all with investigations ongoing at this time. Beyond that, the President has threatened tariffs on films and tariffs relating to digital taxation. Okay, US tariffs are not the only issue, or at least not the only development with respect to tariff policy. The US, of course, is not the only country in the world, and other countries are not passive bystanders in the face of change developments. And so one thing that's also important to get an understanding of is how other countries have reacted and how other countries are likely to react. And in this slide, I've suggested there are two boxes, two categories of reactions that are coming out of other countries. The first set of reactions are what I would categorize as disruptive in the sense that they add to the uncertainty and the volatility of international trade conditions. These include retaliatory tariffs from other countries directly on US exports, but they also include reactions in the form of safeguard or other measures that are designed to protect against surges of imports from other countries. And the EU in particular has been active in talking about imposing safeguard measures specifically to protect against surges of imports from China. And then also there are potential further reactions depending on the way that the trade war develops. We've obviously seen a number of trade measures taken by China that are sometimes asymmetric, I guess, in terms of trade wars. They've imposed export controls on raw materials and haven't just imposed retaliatory tariffs on US imports. So there's a few things going on in the disruptive space. In addition, there are constructive reactions, things that potentially ease the uncertainty and cool the volatility in the market. And into this box, I would put negotiations with other countries. I mentioned before that the UK has concluded an agreement. I know that India is maybe close to concluding an agreement. And there is also potential, I think, for negotiations amongst other countries in order to ease the volatility. dropped out.
We can hear you, Iain, but I think the presentation.
Okay, perfect. Sorry, I was just wanting to check because I didn't have any feedback. So that's great. I'm going to share my screen again to bring that slide back up. I was scared for a moment that I'd dropped out of the discussion. Okay. Okay, and then so very quickly at this point, let me talk a little bit about strategies for dealing with the trade disruptions that arise from all of those developments. And essentially on this slide, which is quite busy, I identify 7 possible reactions, which I will run through very quickly now, and then which I can possibly expand a little bit during the Q&A. So some reactions are in the hands of business. So these are kind of commercial strategies that are available to business. A couple of really important ones that everybody should be doing now. You should be focusing on your customs entries, making sure it's got the right classification, exploring the valuation of the goods and checking that the origin is correctly noted. There's room for some planning around each of those variables with respect to customs entries. So that's one task. A second task is to review cross-border commercial contracts where you are part of a supply chain that involves the US or another country that might be imposing tariffs or other measures. You should check the terms of those contracts. You should check the terms of the arbitration clause, and you should be ready to resolve disputes in the most constructive manner possible if they arise as a result of tariff disruptions. So you should think about things like amicable settlement techniques or international commercial arbitration to ensure that you both get remedies, but also have hopefully a positive solution to an unexpected development. I mentioned that the US is investigating new tariffs on several products under Section 232. There are some opportunities to participate in those processes. The EU is currently consulting on use of its so-called enforcement regulation to determine its retaliation or reaction to US tariffs. And of course, there are always other government strategies available through direct engagement with political actors, either in the US or elsewhere. US litigation is an important option, as we've seen just yesterday with the CIT's ruling striking down IEEPA tariffs. And of course, investors, as the chair mentioned in her introduction, always have options around investment disputes under investment treaties. Those are all things in the hands of commercial actors. In addition, governments have a role to play in respect of US and other government measures. And so, there are opportunities for the Indian government or for other friendly governments to participate in consultative processes. Governments, interestingly, also have standing under investment treaties. They can bring cases on behalf of investors, which is an interesting option sometimes. And then in addition to those options, governments can also be involved in international litigation, for example, litigation under the WTO agreement. Interestingly, Canada, China, and the EU have all initiated or signaled that they will initiate WTO disputes against Trump tariffs. And of course, and I'm going to wrap up here, just a final word, even though some of these actions like WTO disputes are only available in the hands of governments, business and business associations are, of course, important stakeholders who can influence government actions with respect to such disputes. So let me pause there. I think I've stopped sharing, and I'm just going to click back onto that part of the screen. And I'm happy to hand back to the chair. Thank you.
Thank you. Thank you, Iain, for this. I now call upon our second panelist, Dr. Sangeeta Sharma, if you can begin with your presentation.
Unmute. Okay, thank you. Good evening, everyone. Thank you, Vanita, and the organizers of IACC for bringing this distinguished panel and the topic of such importance, strategic importance. And I think I'm the odd person out here. We have CAs, lawyers, and all those very technical people attending here. But I'll be talking about healthcare, importance of investment in healthcare. As we know, it is definitely an economic uh, subject, productivity, jobs, innovations that we all the time keep talking about, and it is directly related to the growth of the country. But I am also going to bring a humanitarian issue here. We are all survivors of COVID here, and we have seen the helplessness caused by the COVID pandemic. And myself being particularly working in the area of antimicrobial resistance and mental health and neurosciences for last 30 years, I can share with you the kind of global health partnership was required and the need for investment in healthcare. Structure in development of infrastructure was required, and both of these are major issues these days. uh, Globally, everyone is struggling with AMR problem as well as with the mental health and neurosciences issues. Now, with this background, the US India collaboration has matured into a quite a strategic alignment here, where while US leads the innovation, they are leading in the biotechnology, India offers a scale, diversity, and clinical depth. We have grown quite a lot over the years, and we have some of the center of excellence, but there are certain issues that still are surrounding our healthcare systems. And I feel together with this Indo-US collaboration, we are poised to build a healthcare system which is resilient, equitable, and innovative, so that that kind of ecosystem is developed. We have made a lot of improvement by, I think you will be deliberating more and you would understand more by taking several steps like performance links, incentives, FDI norms, where the norms for establishing hospitals, diagnostics have been eased. So this has led to a rapid rise in these investments and institutions. PLI schemes have certainly helped the pharma sector and the medical device sector, and the very ambitious mission of India, ABD-DM, Ayushman Bharat Digital Mission is again something which has offered a lot of improvement areas of collaboration. This unified system offers confidence, transparency, trust in the system, and a lot of legal clarities are brought in here. But yet, I feel telemedicine is another area that we have progressed a lot. Telemanas program of Government of India, this mental health platform, this has helped again in cross-border innovation and care deliveries, but there are still certain areas that need challenges that we continue to face. And I think dialogue of this kind will help us in addressing those biggest, I think the first one which comes to mind, everybody's mind is investors as well as healthcare providers' mind is that regulatory complexity. India, there are a lot of complexities there. There are multiple agencies involved in giving licenses, approval, land use, clinical trials, and there is a lot of delay, duplication, uncertainty involved in that deters the investors to come in and invest, because timelines, if they get dragged, it means money for them. So data privacy and ethics, though we have digital platforms, a lot of things we can use AI, data analytics, and US has a very well developed harmonized framework for this, particularly for AI and digital diagnostics. The data privacy and ethics is a concern, although that bill has been passed for data privacy, but implementation part, we have to yet to see. The biggest another challenge that we have is infrastructure gaps, in particularly, that this is in general, and as well more particularly striking in mental health here. Although we have good systems, infrastructures in metro cities, but tier 2 and tier 3 cities are still lagging behind, particularly the diagnostic parts, diagnostics, because this requires high capital expenditures, particularly radiology, oncology, setting up surgical units. These are areas where mental health problems here, both manpower is lacking as well as the infrastructure to handle these issues in tier 2 and tier 3, and especially the rural areas. So this is something that we need to sort out. Then I think insurance and affordabilities, everybody is looking into it. What is in it for me? It should be a win-win situation for both India and US. And I think some of the models, while can be replicated as it is in India, but some of them which are successful in US but need adaptation here according to the local needs here. So investors would need clear localized reimbursement pathways. Medical tourism has grown, and it is India is one of the favored destination because of the infrastructure in the metros and the skilled manpower. But but it. If insurance covers their visit, so we can work in this area. I think depending on these challenges, then we can work on the solutions. I think second round would be about the solutions. So, yeah,
Thank you. Thank you. Thank you, Dr. Sharma. May I now call upon Dr. Sinha, if he can make his presentation? Yes.
Yeah. Thank you, madam. Good evening to all distinguished guests, fellow speakers, and esteemed member of the IACC. It's truly an honor to join this important dialogue on the subject of immense strategic and economic significance. I'm representing a company called Uno Minda Limited, which is the global leader in automotive system and components. And business-wise, India, country's domestic largest auto component organization, having 74 plants across the globe and 50,000 employees in different locations. When we discuss about the India-US economic relation, ease of doing business, and related issues, we are not just aligned to democratic values, but in economic complementaries also. Our trade relationship has been approximate 200. Just I'm in a meeting here. Hello. Sorry, ma'am. We are currently having around $200 billion plus trade relationship with the US, and growing flow of mutual investment signals that we are a pivotal movement. There are some hiccups in the recent past, but it's not a long-term issue. The day is not far away. It will be resolved very soon. And we look forward for the regulatory clarity, governance, modernization, and investment facilitation mechanism to increase this this relationship and ease of doing business with the Indian subcontinents and India for the foreign partners, especially US. So far, the Indian progress in the ease of doing business, I have been a member of the DPIIT ease of doing business, this compliance reduction task force. And so far in last few years, roughly 20,000 plus, DPIIT says that 25,000 plus compliances has been eliminated across the legal framework across the country, and mainly many laws which has been criminalized earlier has been decriminalized in the recent changes. And it's one of the major achievement where country the business people doing the business in country have a little relief because of the so massive compliances. And the another activity, which is the national single window systems in the country, which is taking shape very well. And it's aimed to provide end-to-end digital clearance for all the investors who are coming to invest in India and setting up their businesses and shops in India. It's not in the final stage, but the government of India is working very hard on this, and the testing, etc., and some of the activities and have been already shifted to this, and especially the land-related data, etc., is very well available on this site, and many clearances in many states and central is also coming on the online systems. Uh, Past rollout of GST, which removed many hustles in the trade and business within the country, and the UPI-based payment system, Aadhaar-linked services, and the faceless tax assessment. If I look at my own 40 years in the country, the way tax assessment used to take place 40 years back and today it takes place is it's entirely a different ball game. And the lastly, but recent, the PLI scheme for the many sectors, including my own sector of the auto component, have given a boost to and robust startup ecosystem in the country. There are some hiccups and some misuse of the this PLI and FAME-related issues. But even then, this government of India, different sector PLI schemes are doing very well and attracting a lot of foreign and domestic investment and increasing the make of India and the domestic value addition in different product categories and businesses within the country. Few other governance related things which took place the last couple of years. This is the Insolvency and Bankruptcy Code, IC Gate, GEM, and NSWS, and the Structured Industry Consultation for fast track dispute resolution, and structured industry consultation for new schemes, incentive subsidies, and the PLI scheme, particularly for the new sectors and upcoming sectors. Bilateral, the two-way process, and we promise and we get promise, and there are a few hiccups here also, delay in the sensitive sector approvals, residual uncertainty in tax enforcement. We have seen many tax judgments which disturbs the foreign investment and the ease of doing business in country, and ambiguity in defining multi-sectoral businesses, particularly in my sector, EV, AI, MI, ML, semiconductors, and the facilitation mechanism needs to be more robust. And what are the challenges that demand collective action from the Indian part and the US counterpart is the regulatory unpredictability and the both side, but and the part of data localization, IP and IP enforcement and custom related laws. Non-alignment and high tariff barriers, visa and mobility constraints. It's very getting an Indian visa for others are comparatively easy, except the non-friendly countries. There are some non-friendly countries where we also avoid allowing visa, but rest of the world, Indian visa is very easy. But when you go to US, getting a US visa is really very, very difficult, and it's we know how complex the situation is while getting a US visa at a short notice or for the emergency. Complex compliance norm and both the sides, and sustained political will and the institutional collaboration is the only solution where we can move forward. And we will talk in the second part and the road ahead, how we move forward and what are the strategic recommendations we should do. It's first is the BIT, then the sectoral task force from both the countries, or the IPR and tech transfer facilitation, and the green channels especially green channels for the investment for the US investors, similar to practice in Singapore and UK and a few other countries. State to state collaboration, because we are such a large country. So we need every state to be aligned to one of the state for their US state for the collaboration, localized investment opportunities, and the technology transfer, so that there both sides there is a win-win, and we are reaping the benefit of these fruits. Together we can translate intent into impact and potential into prosperity. I think my time is over. Thank you very much, ma'am. Thank you.
Thank you, Dr. Sinha. Now I call upon our final panelist, Rahul Kapoor. Please, if you can make your presentation. Thank you.
Yeah. Thank you, Vanita. I must say I'm feeling, very special, because I'm amid some very eminent panelists, and I'm sure it didn't go unnoticed that my introduction was the shortest. So, including our moderator, who has, been honored with many prestigious awards and honors. And of course, we have Iain and Dr. Sharma and Dr. Sinha. I must say all the inputs from the panelists have been very, very insightful and very useful. So I today will be talking about some of the seemingly small but very, very irritating regulatory roadblocks which become a daily nuisance for foreign companies who want to set up their companies or generally to set up their businesses in India. And the other thing which I want to cover today, a subject very close to my heart, is transfer pricing. It's funny that like a couple of decades ago, when any of my team members would be working on transfer pricing, which we refer to as TP, in short, I used to always say, "What are you doing?" So if they said, "We are doing TP," I used to say, "Okay, TP, time pass," because it was literally trying to quantify something which is abstract. So transfer pricing addresses issues of differential pricing by different product manufacturers. Say if there's a mobile manufacturer in India who's making, say, a phone which is similar to Samsung, and then there's another one who's making like a Vivo category phone, and then there's something who's competing with Apple, someone who's competing with Apple. So transfer pricing tries to generalize the profit margin which say a phone manufacturer, or say a ceramic cup manufacturer is charging his sister concern in another country, right? So it assumes that if A is charging a 20% premium, or if the industry average is 20% markup, then I should also be somewhere close to it, if not exactly 20%. And obviously, this is very abstract, and it leads to a lot of litigation. It entails a lot of subjectivity, and therefore a lot of confusion. So, firstly, as Dr. Sinha rightly said, the government has been successively making a lot of changes in the regulatory environment and making it easier for businesses to work in India. Like he mentioned, faceless assessment. It is a fantastic initiative, and it not only cuts down a lot of red tape, it also reduces the time of an assessment. And the other thing I'd like to say is that in the last 5 years or so, much fewer cases are picked up for scrutiny assessments. So, it's literally down to 10%, if not less. So that is a very positive development. And then, now we have virtual courts, and equalization levy has recently been abolished. So a lot of initiatives are being taken by the government. But as we all know, it's a very complicated, the whole gamut of things to be done is quite complicated, and it will always remain work in progress. Also, we have some statistics that, coming back to transfer pricing, when a transfer pricing case is taken up for assessment, in more than 50% of the cases, the transfer pricing officer makes an addition, which means he demands more tax from the assessee. Because the way transfer pricing works is that, we have some databases which we are supposed to refer to. And then from that database of all the data of similar companies or companies in the similar line of business, from that we have to pick out the ones which we think, which the assessee thinks are most comparable to his business in terms of size, in terms of product, in terms of the country he's exporting to, so on and so forth. So invariably, we have a database, say there are 200 companies in it. One is a loss-making company. Another one has a 5% margin. One has 25% margin. So we are at liberty to pick any 6. And this is really quite, should I say, funny. So I pick the 6 which suit me the most. So I'll say, okay, I like the 6% because it's very close to my turnover. I am in 100 crore bracket. So is he. So I'll pick up this. Then there's another one in this, in similar turnover bracket, of course, doing the same business as me in the same line of activity. And he has an 8% margin. Then there's another one who has a 12%. So I'll pick those 6, 7, and I'll say their average comes to 11%, let's say. So I'll say, okay, mine is 13%. So therefore, I am much above the average. Now, when the case goes to the TP officer, the TPO, he looks at the same database and now he picks up what he thinks is more appropriate. So you see the subjectivity there. Now, this guy says, the respected officer says, okay, no, hold on. There's this company in the 100 crore bracket. It is making a 20% margin. Then there's so-and-so company, which is making 21%. And so on and so forth. And then he says, according to me, this is a better sample, a more representative sample. And in this sample, according to this sample, the average profit or markup you should be making is 19%. So therefore, now you have to pay me 5% more tax on your entire turnover related to that export to that party. Now, this obviously creates huge demands and a lot of litigation, and it's all very, very gray. The government has tried to mitigate this by coming up with what they call safe harbor rules. So under the safe harbor rules for certain industries, they have specified, like in software, they say currently that if your markup is 18% and above, then you're in a safe zone, which means the TPO will not contest or challenge the percentage which you are charging as long as you are 18% and above, right? But of course, there's a lot of arbitrariness in deciding what should be the minimum safe harbor threshold. So, and it creates a lot of bad blood, a lot of litigation, a lot of demands. And once a demand comes, if you go and appeal, you have to first deposit 20%. Before you go in the first appeal. If you have to go to the next step, which is the tribunal, then you have to pay sometimes 50% or even 100% of the demand, while you are still contesting the claim of the TPO. So, a lot needs to be done in this regard. And this is not only an India problem or an India-US problem. This is a global problem. Everywhere, the ambiguity, the subjectivity remains the same in transfer pricing issues. So we are going to address these issues, and of course, we will also address some other issues, which, as I said, are seemingly minor issues, but they become big irritants when you are setting up your company in India. For example, the verification of the director's background, which means the KYC. So when you set up a company, all the directors or all the subscribers to the memorandum, which is the shareholders, they have to get certain, authentication of documents done back home. In this case, since we are dealing with India, America, so back home in America, they have to, do certain processes which are very cumbersome, like apostillization, which we will talk about, when we come back again. Thank you very much.
Thank you so much. I really thank the esteemed panelists for their valuable insight and sharing their expertise with us. We do have some follow-up questions from our panelists to understand the issue better. So if I may call upon Iain first. Iain, as stated by you, US imposed reciprocal tariffs against all major trading partners, including India, and several states in US have challenged the tariff measures imposed under Section 232, as you mentioned. And you also spoke about certain strategies, but specifically, in order to deal with the possibility of future disruptions arising from Trump tariffs and other countries' reactions, what should companies include in their commercial contracts?
Thank you very much, Madam Chair. I mean, in my comments, I mentioned that the court had actually found against those 10% global tariffs and reciprocal tariffs, as well as tariffs on China, Canada, and Mexico. And that just really underscored for me just how much volatility there is. Things literally change overnight. Tomorrow or the next day or in a week's time, there'll be an appeal on that case. There'll be some kind of motion to, keep the tariffs in place in the meantime, and there'll be some other action as well. So we just, as a lawyer who's used to dealing with facts and a fixed scenario in order to help my clients plan and deal with problems, it's a very disconcerting time because I just don't know what anybody's tariff rate is going to be next week. And so that really does underscore the importance of commercial contracts. Commercial contracts can't take away from the uncertainty either, but they can address the uncertainty. And they can do so in a number of ways. I've been counselling all of my clients who deal with cross-border transactions or who are in a distribution chain as a customer or a supplier to look at their cross-border commercial arrangements, specifically to anticipate the possibility that a good deal at the time a contract is made or at the time an order is made can become a bad deal overnight. If you were exporting from China, for example, there was a moment in time when your goods could be on the water and unexpectedly you face a tariff liability of 145% more than you expected, which obviously is going to cost you a lot of money, or is going to cost somebody a lot of money. So contracting parties need to look at the contracts to see whether the contracts contemplate that possibility, and if so, what do the parties want to do about it? This is disruption caused by government action. We're all in business. We want to deal with each other. We want to deal with each other now and in the future. So it's not just a case of necessarily cancelling everything in the case of a new tariff liability. Instead, you want to come up with, you want to anticipate the problem and try to deal with it in a way in which your relationship can survive, but also in which your business can survive. Because if you're importing a single product, you have to pay 145% duty on it when you import it. You're probably not going to be in business for very long. So you need to deal with that in the round. Specific clauses, you can think about whether there are clauses that actually contemplate tariffs at all. How are they allocated between the parties? You could contemplate price adjustment mechanisms, not typical outside of the context of long-term energy supply contracts, but you could do that in these unusual times. You could look at the clauses that deal with unanticipated events like force majeure or hardship or other unexpected event clauses. By default, they probably don't deal with tariff disruptions because force majeure, for example, tends to deal with impossibility of completing the contract rather than just a bad deal emerging because of a new tariff. But you can craft them as you wish. You have freedom of contract, so you can look at those clauses to make them fit for purpose. You need to look at the conditions for cancellation or termination of contracts or orders. And importantly, you also need to think about the dispute resolution clauses. So can you deal with a dispute that arises from a tariff disruption in a way that either allows you to continue to do business with your counterparty in the future, that's fair and everybody has skin in the game, or in the worst case scenario, that actually allows you to get your money out of the transaction. So will allow for a finding that's on your side, and that provides for an enforceable outcome to that. So you need to think about dispute resolution as well. There are probably a couple of other things too that other lawyers on the group would like to chip in, but that's my checklist of issues for commercial contracts.
Thank you, Iain. That was for a helpful practical advice to navigate the uncertainty. Now, several countries, like you mentioned, have initiated WTO disputes against Trump tariffs, and India has recently notified the WTO of its intention to suspend trade concessions granted to United States. Now, would you say WTO dispute settlement system is still functional, and can the US administration simply ignore any WTO ruling?
Am I unmuted now?
Yes.
Excellent. Thank you very much for that question. I'm particularly pleased to get that question because I've spent a lot of the last 10 years litigating disputes in Geneva and the World Trade Organization. So I always like to tell people that the WTO is not dead, that it still has utility, and that it can still be important in helping to resolve international disputes. Just by way of background, I think it's really interesting to note that that both the United States, India, and other countries continue to participate in WTO processes. So it's interesting that India, notifies that it's going to suspend tariffs within the WTO framework. I think specifically as a reaction to a US safeguard, characterizing the measures as safeguards, which is interesting. That signals there's a degree of legality and an attempt to keep within the agreed framework from India's conduct. So that's very interesting. Other countries have challenged US measures in the WTO through the dispute settlement system, knowing that the US is probably going to appeal any findings, and that appeal process at the moment, because the US is not allowing appointments to the appellate body, they know that appeal process will kind of hold the resolution of the dispute up at that point. However, it's still very useful for a couple of reasons. One, actually it's important for three reasons. One, WTO, using the agreed WTO framework signals a commitment to the international rule of law and a commitment to dealing within agreed frameworks, pacta sunt servanda for the lawyers out there. And that's a really important signal in international relations. Other countries are showing that they are going to abide by the rules, even if the US chooses to depart from them. That's one important point. Secondly, WTO panel decisions, even if appealed, have really important declaratory value, in the sense that they are a statement, an authoritative statement of the legality of a measure that's been taken by the United States or another country. That's important in itself, and that can influence US conduct over time. It's also really important if you're a commercial stakeholder who's bringing, say, an investment dispute against the United States, because factual and legal findings by a WTO panel are going to be looked at by an investment arbitrator and could be influential if they're on point for the issues before that tribunal. And then a third reason is a little bit more technical, but in some countries, the EU, for example, they are obliged to go through the WTO dispute settlement process as a condition for meeting their own legislative requirements for taking countermeasures. So the EU has signaled, for example, that it will initiate WTO disputes in order to try and let the US do the right thing before the EU actually imposes its own countermeasures, at least for some categories of countermeasures. So the WTO is still very relevant, even though it's not working as smoothly as it was, say, 5 years ago.
That's good to know. Thank you, Iain. Dr. Sharma, you highlighted the importance of investment in healthcare and also mentioned how Indian government has pushed for increased FDI in healthcare infrastructure, and considering the push for PM Ayushman Bharat Health Infrastructure Mission to boost up digital health infrastructure of the country. And you've mentioned certain regulatory, infrastructural, and risk-related barriers that may deter sustained private investment in the sector. But can you provide us with insights on how public-private partnerships can help close these gaps and attract investment in the healthcare sector?
Yes, I think a public-private partnership is one of the answers where joint funding, some assurance from the government side is there. And, a lot of this risk is because of the uncertainty that they have, or unpredictable timelines that we have for regulatory approvals. So I think this has to go hand in hand with that. We need to work on a single window clearance system for all approvals related to medical, pharma supplies, devices, be it the use, license, land use, or it is the clearance, importation, setting up of a factory, or maybe you can say environmental clearance. So all this, if this is unified, that will help de-risk the invest. And of course the government funding can provide some security here. And particularly we need to think of the innovative models of collaboration partnership for the tier 2 and tier 3 cities, because metros somehow have developed and have these infrastructure. Tier 2 and tier 3 do not have this. So perhaps investing in digital technology and mobile diagnostic technology would be more cost effective and scalable, and you can provide these services to for this. Then another partnership area could be exchange of academic excellence, that you train people so you can fill that infrastructure gap of service providers. In India, again, we have that gap. So if we have exchange programs and co-branded fellowships, that would add value, or some innovative grant for some of these, particularly in the area of mental health and substances abuse problem. This can help us solve this. Then another area of partnership could be the setting up of centers of excellence. So they can provide you the skilled manpower here, and then they can provide these services. So these service of excellence are needed in all areas, more so since I belong to mental health, so I always talk about it. But certainly, the number of people suffering from mental health issues these days is so high. Earlier the prevalence was 1 in 7. Now it has come down to 1 in 4 people globally, not in India. In addition, we have a problem that the psychiatric facilities, the skilled manpower, clinical psychologists are not, mental health professionals are not so much available. So these joint programs. Then clinical trial is another area. We have a lot of patients, diversity is there, number of diseases is there. If we have a joint clinical trial, global network, something like that, that can help solve a lot of these regulatory issues. Although India has advanced a lot in the ethical framework, we have guidelines and these are in place. People are following this. But if we have a global network, that will further help us in filling these gaps, challenges that we have. And particularly, one more thing about the public-private partnership for the startups, the manufacturing units, technology transfer is something that we need to work on, and where the Indo-US collaboration can help in long term. We need not look at only the immediate requirement, but we need to look in the longer term requirement so that we can make an impact, in the healthcare. Thank you.
Thank you, Dr. Sharma, for your valuable inputs for a very important sector, as you mentioned. But considering the forum, I mean, as we all know, India and US are negotiating a trade deal, and as per reports, the pharmaceutical sector has emerged as a key area of negotiations, with India proposing a number of reforms and incentives to expand its generic drug market in US. So how can both nations deepen collaboration in emerging areas, like you said, in important areas like digital health, AI-driven diagnostics, and clinical research, and while ensuring equitable access for both
Yeah,
countries?
definitely. India is the hub, the second pharmacy of the world. We are supplying to this. We need to invest a little more into the quality of this API and all that. If we those gaps, if we are able to fulfill, then I think we can master this. The quality. Now we need to work on the quality as well. Uh, Quality strengthening of these manufacturing houses is needed. Um, um, Big companies, they don't have any problem in meeting those standards, but the medium size sector and the small sector, they are facing. So we need to work on that. So I think this is something we need to do at the national level.
Thank you so much. Uh, Dr. Sinha, if I may ask now, with your background in HR, now labor-related challenges continue to be a significant barrier to improving ease of doing business. And striking a balance between protecting worker rights and enabling market flexibility is essential. So, what, according to you, can be done to meet the challenges of multiplicity and complexity of labor laws, low formalization of workforce, lack of skilled labor, etc.?
Plenty of things, ma'am, but there are three, four things which needs to be taken up as soon as possible. One of which is already being taken up by the central government. That is the simplification and harmonization of labor laws. The consolidation of plus 100 labor laws have been made into four different labor codes, which is a very positive step, because referring those labor laws and getting them in compliance, it was very, very difficult. But the effective implementation of these four labor codes are still in the process and not fully implemented. And the uniform adoption by the different states is still is a question mark. Being a federal setup, we are struggling for that uniform adoption by the states also, which is very, very critical. We also need to have a unified digital compliance portal, because there are much more controlled inspector Raj, but still there is a compliance related issues where the investor or the organization coming from abroad facing a lot of challenges of undue practices. The unified digital compliance portal for employers, workers will reduce administrative burden and enhance transparency, as well as it will remove the fear of compliances. So that will be one thing. That is, second is the formalization of workforce, because there a lot of employment is being generated in MSME, and now the gig employees are also coming very well in the starting phase of the life itself. So we need to, central government and state governments needs to incentivize those MSME workforce to bring these workers into formal net through reduced regulatory overheads, contribution-linked incentives, and expand use of tools like portability of various social security schemes. This is the second thing. And third is which is the most important, is the skill development aligned to the industry needs. That is one of the things, if this is not coming in place, because then there will always be mismatch, and mismatch will lead to frustration, and frustration will lead to industrial unrest. There are a lot of happening in the industry academia partnership, dual vocational training models, a lot of focus on the apprenticeship from the central government and the localized skilling hubs. But some of the skilling schemes have gone for a toss, and it was not properly utilized and misused. In a sense, it was misused. So that another schemes which are coming, which will be, I think, which will be more robust and more foolproof to avoid any misuse. And India also can draw the US model, where flexible hiring is supported by strong retaining and workers mobility ecosystem also. the goal should be enable to labor regime is fair, future ready, and business friendly. So we need to focus on fair, future ready, and business friendly. Then only this industrial relation and labor related challenges we will be able to take care and abolish it, ma'am. Thank you, ma'am.
Thank you. Speaking of skilling of labor, now a restrictive US visa regime, as is proposed, may result in fewer Indian students studying in the United States, which historically has been a top destination for advanced education and skill acquisition. And India's IT and technology sector, and as Dr. Sharma said, even in the pharmacy sector, a key driver of the economy and foreign investment relies heavily on movement of skilled professionals. So, according to you, will this development affect the access to skilled human capital, a key pillar for ease of doing business?
For short term, yes, but long term, it's not going to work because the US also need people to work in both sides, intellectual side as well as the execution side. Even morning, the student visa holding and the social network scanning, all those news are not that good. But we all know it's not going to prolong and it has to be reduced. Uh, this is a very tricky and double-edged sword also. You can stop people coming inside the country, but who will work for you and how you will get the things done? That question is coming very soon, and the talent gap will broaden, and economies will naturally lose their edge, and finally they have to come back to a normalcy and allow all those things, because this gap, increasing this gap, and we know that US companies are mostly depending on the Indian talent, and loss of global upskilling opportunities for Indian workforce will be missing. They will be going somewhere else, working in Indian subcontinent itself, but it will be lose and the game for the US counterpart. And we all know that it's going to come back to normal very soon. It's not far away.
Thank you so much, Dr. Sinha. Mr. Kapoor, so India has enhanced the regulatory landscape to support launch of business and operations, as we mentioned. However, there's still a long way to go. And so, according to you, what are some procedural difficulties to address regarding foreign-owned companies in India vis-a-vis setup of business and cross-border transaction?
Yeah, thank you again. So, as I said earlier, when you on a pragmatic level, when you set out to incorporate a company in India, you face so many irritants and so many time-consuming procedures, which otherwise seem very simple and innocuous, that they actually, discourage investors from the US to come into India and set up their companies. I'll give you a small example. When you start a company, say you are 4 shareholders, right, who want to make the initial investment in the Indian company. Now, the Indian process requires all 4 of them to get their ID verification done under an apostillization mechanism, as opposed to a simple certification or a notarization, where you go to a notary public and you get your documents notarized, and that is the end of it. India requires them to get it apostilled. And apostillization means that you have to go to either, in the case of America, either you have to go to Washington, D.C., or you have to go to the Secretary of State office, which is just one office in every state, to get your documents apostilled. Can you imagine now, some states are so large, say, say California, right? It's such a large state. Now, if I'm on the west end of California and I have to travel all the way to the east end, or wherever the Secretary of State's state office is, to just get my documents apostilled. And the same thing has to be done by the other 3 directors as well, other 3 directors stroke shareholders as well. So it becomes a very cumbersome process. Now we'll show you on the screen how different our requirement is of apostillization is from that of other countries, some other countries. Lee. Okay, so as you can see on the screen, so we have picked India, the US, of course, Singapore, UK, and the Netherlands. Now you'll notice that India, of all the countries, India is the only country which requires the documents to be apostille. And what are the documents to be apostille? The certificate of incorporation, in case the shareholder is a company, the investing shareholder from the US is a company. So they get their certificate of incorporation apostille. Then there are many other documents which require apostillization, right? Like, when you're doing FDI, then also if you're giving a power of attorney, it needs to be apostille. And the apostillization framework is so gray that even the banks do not know what the validity of an apostille document is. So very often you go to a bank with an apostille document, which is say 12 months old, and he'll say, oh, no, this is very old. You get it apostilled again. And the reason for that is that there is no, structured framework for apostillization. There is no policy or a rule or a law which says that this apostille will be valid for 5 years or 3 years. So everybody is doing it the way they feel comfortable. One bank will say after 6 months, you need to get it apostilled again. The other one will say, for me, 1 year, more than 1 year means it's stale. Now compare that to the United States. Apostillization not required, which means if I have to set up, being an Indian, if I have to set up a company in the US, I don't need to run to the apostille office or, to the American embassy, the Indian embassy, which will then apostille my documents, right? And similarly, Singapore may require it in very exceptional cases. Mostly it does not. United Kingdom not required. Netherlands sometimes required for non-EU incorporation certificates and other documents. So you see, this itself makes it, it's abundantly clear from this chart that this is a unique requirement of India, right? And the whole framework is very gray. Now imagine the plight of the person who's running from pillar to post to get his apostillization done, and then being asked to do it over and over again, as and when he requires it for, various other documents, right? The other very peculiar requirement of Indian banks is KYC, know your customer. Now, of course, we know KYC is very important for various reasons to prevent, unwanted elements to set up businesses in India or set up bank accounts in India. So it's a very fair requirement. But the problem is not the requirement per se. The problem is, again, the framework surrounding it. Now, you look at this chart now. The validity of a KYC document in India is only 3 months. Can you even imagine? We have a real-time case of an American company which had 3 directors and they had to open a bank account in India. Okay, this is a documented ongoing issue which we are facing. Now, 2 of the directors have got their KYCs done. The third one, who shuttles between Paris and New York, he could not get it done for 3 months because of his business travels. Now, he got it done after 3 months. We submitted all the KYCs to the bank, and the bank said, oh, no, hold on. The earlier 2 KYCs are now stale. Now, you won't believe it, my friends. We were embarrassed to go back to the client and tell him that, look, now your KYC is not valid. Now, imagine a person who has been KYC'd. How can he change, or how can his antecedents change in a short span of 3 months? Isn't that very illogical and unreasonable? So these are issues which we face on a day-to-day basis, right? Now, again, a glance at the chart will tell you that in the United States, for a KYC, there is no fixed validity period, which means it is almost perpetual unless revoked, right? And the basis on which it lapses is not time based like it is in the case of India. As soon as 3 months are over, irrespective of what happens, your KYC is now stale. In the US, it becomes stale only if there is some event which triggers the government to revoke it, or there is some new risk perception, like you have changed your address, or something like that, or you have some say some criminal case against you, for want of a better example. So then they say, okay, now the risk has increased, let's do a KYC again, which is fair and logical, isn't it? But in India, it just lapses after 3 months. In Singapore, the validity is 1 to 5 years, UK 1 to 5 years, Netherlands 1 to 5 years. And again, the validity is not time-based. So you can imagine how much agony it causes to a guy, to an investor who has to go and get his KYC renewed once again. And it's not an easy process, because you have to again go to the notary, get it certified, then you have to scan it, then they want the original. So the originals are couriered, they come after 7 to 10 days. So it becomes a big pain. So these, small things are things which the government must take a serious look at. And the other thing I want to mention is that KYC requirement or validity or expiry is the same for all the countries. The government can identify some countries which have a higher risk, right? And they can say that, okay, for this country, we want to prescribe a 6-month validity period. But for countries like, the United States, or maybe even the UK or Singapore, they can say, okay, for these countries, we have a higher validity period. At least make it logical. It should not be, a one-size-fits-all approach. So, these are the two, irritants, daily irritants. And the two others I would like to talk about are TRC. Every time you make a foreign remittance, you'll be surprised to know that the recipient of the funds has to furnish a tax residency certificate of that country. Okay, it's also a valid requirement, because there was a lot of misuse of the tax treaty benefits. Because say a Singaporean company or a US company sets up a small office, not a subsidiary, an office in UAE, and then when it receives payments from India, it tries to get the benefit of the UAE India tax treaty by positioning itself as a UAE company. So then the government said, okay, no, we want to see your tax residency. Just because you have an office and a letterhead and an address there, it doesn't mean you're a UAE company and are entitled to the Indo-UAE treaty benefits, which was a valid ask. But here's the problem. How do you get the TRC? To get the TRC, you have to apply to the Indian government. There's also an online application which was recently, enabled, but it doesn't work. The normal course is you go to the income tax office, and guess what you tell the income tax officer? You say, hi, I'm Rahul Kapoor. I pay taxes in India. You've given me a PAN number. Here is my tax return. Now you tell me, you give me a certificate that I'm a tax resident of India. The question is, why cannot this be simplified? Why can't I, a valid taxpayer of India, go to the income tax portal, put in my user ID, password, etc., and make a request for a TRC to be issued to me? And why can't it come within, say, a day? Why do I have to wait 2 months, 3 months, go and meet government officers, make repeated visits? It can take 3 to 10 visits to convince the guy that, look, I'm a valid tax resident of India. Please give me a TRC. And the same thing happens at the other end. Whether you're making a payment of $3,000 or $30,000 or $3 million, it does not matter. They are agnostic to the quantum of your payment. So many times clients, they fight with us. And I'm telling you seriously, clients call me up and say, your team member is saying I cannot issue a Form 615 CACB which is required to make a foreign remittance, because they are insisting that my small vendor, say in the Netherlands, should furnish a TRC, even though my payment to him is, say, he's a photographer. Like we have a media company which is required to make a lot of foreign payments. So they have a photographer, let's say, in the Netherlands. Now the photographer has to be paid $5,000 or $2,000. Now they want the photographer to furnish a tax residency certificate of the Netherlands before a remittance can be made to him. I mean, how absurd is that? So, and because multiple payments have to be made, multiple TRCs have to be obtained by so many people across the globe and to be given to the person who's remitting the money. I mean, this is absolutely absurd in my opinion, and the government must review this process. They could also consider making some thresholds, like up to $10,000, you can make the payment by just taking an income tax return of the person or the tax registration number, like we have a PAN number in India. So based on that, the payment should be allowed to be made without having to furnish a TRC. So these are the daily irritants which become such a big nuisance that they take the fun out of doing business in India.
Thank you, Mr. Kapoor. With that, we have come to the end of our session, and we thank our esteemed panelists in this session, which I'm sure has given practical solutions to our audience for navigating and conducting business, especially considering the current uncertainty in the US-India corridor. Suggestions made by the panelists are well noted, and we hope that IACC can be instrumental in helping positive suggestions to be taken forward. And I guess the key takeaway is simplification. With that, I thank my esteemed panelists for your valuable time and expertise.
Thank you. Thank you, everyone.
Thank you.
Thank you, everyone. Bye-bye.
Bye.